5 seconds to go. Start. An appeal may lie under this section from an appellate decree passed ex parte. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal, where the High Court is satisfied that a substantial question of law is involved in any case, it shall formulate that question. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question, provided that nothing in this subsection shall be deemed to take away or abridge the power of the court to hear, for reasons to be recorded, the appeal on any other substantial question of law not formulated by it, if it is satisfied that the case involves such question. Rule 1 to 3 of Order of the CPC provide for procedure for deciding a second appeal in the following terms. At the time of making an order under Rule 11 of Order 42 for the hearing of a second appeal, the court shall formulate the substantial question of law as required by section 100, and in doing so, the court may direct that the second appeal be heard on the question so formulated, and it shall not be open to the appellant to urge any other ground in the appeal without the leave of the court, given in accordance with the provision of section 100. Reference in sub rule 4 of rule 14 of order to the court of first instance shall, in the case of an appeal from an appellate decree for order, be construed as a reference to the court to which the appeal was preferred from the original decree or order. It is clear from the aforesaid provisions, particularly subsection 5 of section 100 of the CPC, that an appeal shall be heard only on the questions formulated by the High Court under subsection 4 thereof. The expression appeal has not been defined in the CPC. Black's Law Dictionary defines an appeal as a proceeding undertaken to have a decision reconsidered by bringing it to a higher authority. An appeal is judicial examination by a higher court of a decision of a subordinate court to rectify any possible error in the order under appeal. The law provides the remedy of an appeal because of the recognition that those manning the judicial tires to commit errors. In the well known work of Story on Constitution, it is stated that the essential criterion of appellate jurisdiction is that it revises and corrects the proceedings in a cause already instituted and does not create that cause. The appellate jurisdiction may be exercised in a variety of forms and indeed in any form in which the legislature may choose to prescribe. Stop.